On November 8th, the Supreme Court is going to hear arguments on this question. Did the Ninth Circuit err in breaking with its own prior precedent and the findings of other circuits and the Copyright Office in holding that 17 USC Section 411 requires referral to the Copyright Office where there is no indicia of fraud or material error as to the work at issue in the subject copyright registration? I'm Mike Steger. I'm a copyright and trademark attorney, and I'm going to try to explain this to you in English. As we've discussed in prior videos, in order to file a lawsuit for copyright infringement, the copyright owner must have a copyright registration. Without a registration, you cannot file in federal court, you cannot bring a suit. The defense bar, who in my opinion is almost always representing copyright infringers, one of their first tactics is to try to attack the copyright registration and say that it is invalid for one reason or another, especially in cases involving a group or collection registrations of fabric textile designs or photographs. And there are certain rules with these types of registrations that I've discussed in other videos that they usually have to have the same author, the same copyright owner, and if they are published or unpublished, the works have to be in all in the same category. Some of these rules have changed over time. Frequently, the copyright owners are filing these copyright applications themselves. As we've discussed, copyright applications are generally not that complicated. You often do not need a lawyer to handle them. But with these collections, sometimes there are mistakes. There are mistakes as to dates. There may be mistakes as to a few of the items listed in the application. And courts have traditionally held that if those mistakes are innocent, they were not intended to defraud the Copyright Office, or if the mistakes are not material, it should not affect the registration. A decision last year in California held that even if the mistakes were innocent, but the copyright owner should have known of the mistake, that could be grounds to invalidate the copyright registration. The Supreme Court is hearing arguments on this on Monday, November 8th. A colleague of mine who I've worked with extensively is handling the argument for the copyright owner in that case. And there should be a decision early in 2022 from the Supreme Court as to what the standard is for invalidating a copyright registration if there are unintentional errors in registration. If you have any questions about your copyrights or questions about copyright infringement, I'm Mike Steger. I'm a copyright and trademark attorney. Give me a call.